And on the line, I'm joined by a Southern Africa Litigation Center lawyer and somebody who was very central to this case, Mayor Chikondi Chijozi, who is joining me from Malawi, I do believe. Mayor Chijozi, good afternoon to you. Welcome to Duma FM.
Afternoon, how are you?
I am great. I'm so glad that I'm able to reach out to you to give us, some the main points of this case. Perhaps let's start off with a bit of background in laying the foundation of that which we'll then talk about leading to the judgment itself.
Okay, all right. So this case, we had two applicants. The first one was a young man who was in secondary school, who was selected to a government secondary school in 2017. And when he had gone to the school for enrollment, he was told that he cannot be enrolled at the school because he had his dreadlocks. He is a Rastafari child. So because of that, he was denied admission into the school. So he went to court to challenge that decision, and he also made an application for an order of injunction compelling the court, the school to allow him to be admitted in the school. So the court granted him the injunction, and he was admitted at the school pending the finalization of the matter in court. And whilst that case was still in court, that one happened in 2017, but then in 2019, towards the end of 2019, there was another girl in primary school at another government school who was also denied admission at the school because she refused to cut her dreadlocks. So when that case happened, and because there were also a lot of Rastafari families that were coming to report of their children being denied admission into government schools, and we thought that it would not make sense that we approach the court for each and every child. So in the second case, when we went to court, the way we drafted our pleadings was to make sure that it also protects all of the Rastafari children. So apart from seeking an order to compel the school to allow the children to go back to school, for this particular child, we actually also applied that the injunction should apply to all of the Rastafarian children. So in 2020, we got a court injunction which compelled all the government schools to admit all Rastafarian children into government school pending the final determination of the cases that were brought. So from 2020, we went into discussions with government because they were of the view that they will be able to settle the matter out of court. But then we failed for a period of over a year to agree on the issues, and eventually we had to go back to court just towards the end of last year. So it's only 2 days ago that we got the judgment from the court which affirmed the rights of the Rastafarian children.
Mm-hmm. And before we get into the key arguments put forward in the case, what specific constitutional rights were found to have been violated by the policy? And how does this judgment contribute to the protection of these rights in Malawi?
Yes, so the rights that were being challenged in terms of being infringed by the government policy to compel all learners to cut off their hair, including Rastafari children. In particular, for the Rastafari children, the rights were the right to religion, because we know that keeping dreadlocks for Rastafarians, it is a symbol of their religion and a symbol of purity. So for them, it was... we dwelled much on the right to religion, but also issues of equality in terms of access to education, and of course the right to education itself. And also we were looking at how it is unjustifiable for the government or the Ministry of Education to limit their right to education and right to religion based on the fact that they refuse to have their hair.
Right. And I guess you've already got into some of the arguments that were presented in court, and the question might be then, how did the court respond to these arguments?
Yeah, so in essence, the court agreed with all the issues that we raised, that actually the policy of government requiring all learners to cut off their hair, it actually violated their right to freedom of religion, their right to education, as well as the right to equality. And also the court went further to look at how religion doesn't have to be proved, despite the fact that the beliefs can be absurd or cannot be understood by those that do not follow that belief. But if it's a religion that is well practiced and well known for so many years, people cannot be called to justify why they believe in that. And in the case, we also had an amicus who joined the case, which is called the Lost History Foundation. In their submission, they also dwelt on the historical part of dreadlocks within the African culture, and they looked at how historically Africans used to wear dreadlocks. That with the coming in of colonialism, it kind of dehumanized dreadlocks, and they talked about how slaves were actually forced to cut off their hair as a symbol of denouncing their Africanness. So the court also highlighted on the importance of embracing our Africanism, and that it is part of our cultural identity in terms of the right to cultural practice and all of that. So that was also another angle that the court looked at in its judgment.
Right. Now, do we foresee government appealing the judgment? And further to that, in what ways do you anticipate this judgment will actually influence the educational system in Malawi and perhaps contribute to a more inclusive environment for students from diverse religious and cultural backgrounds?
In answering the first part of the question, whether the government will appeal the decision, it's most unlikely they will, because throughout, like I said, in judgment, that they wanted to settle the matter of court, but we never understood why they couldn't settle it until we had to decide to come to court. And also, they did not file any substantive arguments in opposition to the application. So the issues that they had raised with the court was that the policy does not exist. There's no written policy to that effect, despite the fact that all learners in all government schools are expected to cut off their hair, and which is something that is well known. It's not a secret, and the fact that we have all these large numbers of Rastafarian children that are sent back from school are denied admission in itself, it speaks about the policy, whether it's written or unwritten. That's what even the court stated, that whether the policy is written or unwritten, but it is lawful and unconstitutional. So the fact that they did not put up any substantive argument shows that on the substantive issues, they do not have really a position to counter what the applicants had put before the court, but only denying on the basis that
right.
No hard policy that you can show. Yeah, exactly. In terms of how the decision is going to affect the education system, I think it is going to have a great impact in terms of inclusiveness. I think we have grown up in a society where Rastafarian children have not been able to access education freely. So to have them come in, I think it will also create an opportunity for inclusiveness. I think it's something that will be developing in our education system, which is also a requirement of the law in terms of the Education Act, that there should be inclusivity as well as accepting diversity of people. So it's going to be quite interesting in that regard.
Right. And, this begs the question of whether one needs to now prove their religious affiliation for them to benefit from something like this, whereby, a child is coming in, whether that child is of Rastafari affiliation or not, is it going to categorically, mean that kids can come to school with dreadlocks? Because by asking for their religious affiliation, it's somewhat, in a way invading their space, or, infringing on a constitutionally entrenched provision.
Yeah, I think the most interesting part is that when the court's decision does not just dwell on the right issues, but also it has encompassed the issues that were raised by the amicus in terms of accepting Africanism, and that wearing of dreadlocks is part of our culture as Africans. So I think when you come to look at the judgment in entirety, it doesn't restrict just for Rastafarian children to be enrolled, but it also includes those that want to embrace their cultural, the Africanism in sense of expressing it by wearing their hair in dreadlocks. The decision should be able to protect everyone who feels like, I am doing this because this is how I want to look, and this is part of how I want to express my Africanism.
Interesting. Well, thank you, Mayor Chijozi, for sharing those insights with us, and we will be keeping a close eye on developments moving forward in Malawi pertaining to this issue.
Thank you so much.